Compliance and compassion. That's what we're talking about in today's live. My name is Emily Sumner with Sumner Immigration Law, and we are fortunate as immigration law professionals here at Sumner Immigration Law to work with a number of employers and clients and other individuals who want to stay in compliance with immigration laws and also want to be compassionate for the amazing foreign national talent workforce that they work with. So in today's episode, we're talking about how to stay in compliance and how to stay compassionate in a situation where an employer needs to have layoffs or potentially furloughs. So let's get into it. The first thing to keep in mind is that compliance really matters, especially if you hire foreign national employees, especially who are on H-1B or other visa classifications like the H-1B1 or E3, where there are labor condition applications. That's different from the perm labor certification process. But there are compliance considerations that you need to take into consideration in addition, of course, to any employment law considerations that are relevant to your particular state. So if you are an employer, you hire foreign nationals, and you have a situation where you have layoffs or a reduction in force, there are certain steps that you need to take to comply with the H-1B regulations. Number one, you have to let USCIS know that you are terminating the person's employment. So you withdraw the H-1B petition with USCIS to avoid ongoing wage liability. If you don't take all these steps I'm going to talk about, all these steps that I'm talking about, it is possible that you would still be on the hook for ongoing wage liability down the road, even though the person is not still employed by your company. So number zero, first is, of course, to take the steps that you ordinarily would in compliance with any relevant employment laws to terminate the person. But immigration-wise, you have to let USCIS know. Second, Department of Labor notification. The regulations say that you'll need to withdraw the LCA that's associated with the filing. Keep in mind, if you have multiple positions on the same LCA, that's going to be tricky. You don't want to withdraw an LCA that's tied to, if there are multiple people tied to the LCA, and we don't do that a lot in our practice. But if you do, you don't want to withdraw an LCA that is tied to a petition that is still active and ongoing. So be aware of that. The timing for this is important. You want to do it as soon as possible following the termination. And of course, this isn't it is related to immigration. You have to, of course, pay all the wages that are owed. They're also make sure, like I said, that you're complying with any employment laws and regulations that are applicable to your particular situation. In addition, for H-1B compliance, the employer has to offer to reimburse the employee for return transportation to the worker's home country if the employment is ending before the H-1B period expires. So if it so happens that the employment period is ending at the end of what would be the end of their H-1B period anyway, you may not be required to do that. But if it's ending early, you do have to offer return transportation home. And keep in mind that obligation is applicable only for H-1B workers, not for their family members as well. When you take these steps, so you're taking these steps of USCIS notification, Department of Labor notification, and offering return transportation, you want to keep a written record of the termination date. Of course, it's good practice just in general. I don't practice employment law, but probably a good idea in general. Keep track of the dates that you withdrew the LCA and that you notified USCIS, and keep documentation of that offer for return transportation home. You'll want to keep all of this documentation together in case you are in written. You don't want to just have an oral offer of return transportation home. You want to have it documented so that you're able to present that if you're ever audited by the Department of Labor. And also I would keep communication, just in general, of any communication that you have with your employee about the termination. So what if you don't want to lay off this particular employee? There are other options. And of course, we have clients who ask us this frequently. Again, this goes to compassion, right? You want to take care of them, make sure they have the option to stay in the United States if they have the opportunity. So other options, if you don't want to completely lay them off, or if that's not what you're doing for your workforce, a lot of times employers will ask us if they can furlough temporarily employees, and they're doing that for other employees. They're having a furlough where they're not paying their employees aren't working for a period of time. Unfortunately, that is not a thing in the H-1B context. If you continue to employ the employee, they have to be paid the wage according to the labor condition application, the LCA. And it's not possible to furlough them and to say, hey, we're not able to pay you. Please don't work for the next month until things turn around. So if you are in that situation where you're furloughing employees and part of your workforce includes foreign nationals, please have a conversation with your immigration lawyer or find a qualified immigration lawyer. I'm happy to help, but talk with somebody who's qualified and a qualified immigration lawyer to see what your options are there and to make sure that you're staying compliant. If you need to reduce the hours worked, that also is another possibility that we see a lot with our clients is they don't want to terminate a person entirely, but they want to reduce their workload, potentially temporarily, maybe long-term, who knows. If that's the case, you may need to file, depending on how your filing was structured, you will likely need to file an amended H-1B petition. I know employers don't want to hear that. If you're reducing hours, probably funds are not really where you want them to be, and it does cost money to file an amended petition, but that's what you need to do to stay in compliance. And really, staying in compliance is so much less expensive. Taking these steps, thinking them through, being really intentional about it, ultimately is so much less expensive than dealing with an audit and potential fines and back wages down the road. So it is worth it to have a conversation with your immigration lawyer and come up with a plan. But an amended petition to go from full-time to part-time, at least temporarily, could be a possibility. Sometimes it's possible to transfer an employee to a different position within the company that is not being affected by layoffs. That's not quite as common. Again, that might require an amended petition. So if you do that, make sure you have a conversation with your immigration counsel before you do that. Making sure that you are complying with immigration regulations and that you're as compassionate as you can be with it, I think is really important for your reputation as an employer in the long term. Employees talk, foreign nationals talk, and even though you might be in this difficult and unfortunate situation right now where you have to do some temporary reductions in force or reducing hours, you want to handle it appropriately because you don't want to negatively affect your reputation amongst the workforce. So, in conclusion, you want to make sure that you are focusing both on compliance and compassion. Both of those things, I think, are equally important. In our next live, next Tuesday, we'll be talking about options for H-1B workers, the individual workers who are laid off. We'll be talking about the grace period, the last day of employment, options that you might have during that 60-day grace period, assuming that you have it, and not everybody has it. So make sure to tune in then for additional information. If you found this video helpful, I hope that you will share it with a family member or friend. Make sure you're subscribed to this platform, whether you're listening on Facebook, YouTube, or LinkedIn, so you don't miss our next video. Until next time, my name is Emily Sumner with Sumner Immigration Law. We serve clients around the world and around the United States with family-based and employment-based immigration matters. Until next time.